All right, welcome everybody. We will have people joining us. Yeah, there's someone knocking on the door right now, but we're going to go ahead and get started because you guys were all on time, so I want to reward that. Welcome to Lunch with Liz. I'm Liz. I'm your host this afternoon. I'm excited to have this particular topic, which we'll get into in a second. I am an estate planning attorney. My main office is in St. Petersburg, Florida. And so when people say estate planning, what I mean by that for me is I do things like wills and trusts, which we're going to talk about today, powers of attorney, living wills, which are different than last will and testament, and then everything that comes along with it, like probate administration and trust administration as well. Additionally, I do some Medicaid planning for people that are going into long-term care. So think nursing home planning. I started Lunch with Liz a few years ago because I found that there was a lot of misinformation out there. I don't know if you guys know, but not everything you read on Facebook or other social media avenues is true, right? And oftentimes, your second cousin's best friend's sister doesn't know what they're talking about. So I thought this would be a great venue to have a way to talk about the realities of estate planning. And I didn't want to do a podcast where it was just me talking to the air out there. I wanted to do it more of a conversation so that if you had a question, and this is what I mean for today, if you have a question about wills versus trusts, I want to make sure you get that answer today. You came on and you're spending your this hour with me. So if I don't, for some reason, don't address the idea that you have in your head about what you wanted to get from today, make sure that I know that. So how it works is I'm going to do a short presentation. So you're going to be like back in high school. So there's going to be some slides even. I promise there's only three though, so it won't be overwhelming. Um, and then we're going to open it up to questions. If you have questions during the time I'm doing the little presentation, for heavens, for sure, come off mute, throw your question into the chat. For those of you that aren't familiar with Zoom, depending on what type of computer you're on, but somewhere on your screen, there should be a chat function. And that's where you can type in your questions. And I may not see them right away, but I will go and look for them to answer them throughout the process of today. Um, if again, this is for you. So if we need to zig and I intended to zag, we're going to zig because I want to make sure that you get out of it what you want out of it today. So today's riveting topic that brings you all here is the difference between a trust and a will. So I'm going to read you the definitions and they're not going to make any sense. And that's why we're here, right? So a will is a legal document that outlines how a person's assets and affairs should be handled after death. And that's the key thing to remember about a will is that a will is a legal document that dictates how a person's assets and affairs should be handled after they die. Okay. So a will doesn't take effect until after the person who drafted the will is deceased. That's a will. And we're going to come back to all this. Don't worry. A trust is a legal arrangement where one party, and that party is called the trustee, holds and manages assets on behalf of another party. And that party is called the beneficiary. Well, that makes about as much sense as a box of rocks. And we're going to get into both of those definitions and what they mean practically to you as someone who may be thinking about estate planning, thinking about estate planning for your parents or your children as well. So, one thing I want you to keep in mind is that if you have a trust, you're going to have a will. So it's not like it's one or the other. A trust plan is going to come with a will as well. Whereas if you're just doing a will, you're typically not going to have a trust if you're going with the will-based plan. So I know some people are visual learners. So I want to share my screen because I do have some slides that I think would be helpful. No, I lost me. No, I lost you guys. All right. All right. So remember, for those of you just joining us, welcome. Welcome. I'm Liz. I'm your host. We have gone through how today is going to work. So let me just hit that again for those of you that are just coming on board. I have 3 slides to go over about the differences between a will and a trust. We're going to go into some examples and some scenarios. And at any time, you can ask a question. You can come off mute. You can throw your question in the chat, whatever you feel comfortable with. I won't get to the chat right away. I'll do that after I go through the slides. But if you have a question and you don't want to forget it, go ahead and throw it in the chat and I'll get back to it for sure. So I've read you the definition of what a will is and what a trust is. And they made probably no sense whatsoever. So let's get down into the weeds a little bit about what a will is. Remember what I said, a will only takes effect at death. And if you are relying on a will, a last will and testament, to transfer your assets at death, there will have to be a probate to do that. And for those of you not familiar with probate, I do a whole lunch with Liz on what probate is and also how to avoid it. But what probate is when a judge from the county where you live, so Pinellas County, if you're in Pinellas, Manatee County, if you're down there, some judge in your county oversees the distribution of your estate. So they see if you have a will, and if you don't have a will, they apply Florida law to your assets. They determine who your heirs are. They determine who your debts are, if they're valid, and all that. Usually, a process that takes anywhere in Pinellas County, Manatee County, Hillsborough County, anywhere roughly between 6 months to a year, sometimes longer. Because of that, and because of the expense of probate, most people want to avoid it. Not everyone. Some of my clients are happy with their assets going through the probate process, but by and large, the vast majority of people want to avoid it at least as much as possible and have as few assets as possible going through probate. But we're not talking about probate avoidance too much today. We're going to be just talking about the difference between a will and a trust and how those are used in the estate planning process. So what the will does is it directs what happens to your money. So think about what's in your bank accounts. It directs what might happen to your real estate. So condo, house, vacant land, timeshares. It dictates what happens to your personal belongings. So your stuff, your clothes, your furnishings, your car, that kind of stuff. Things in your safe deposit box, your timeshare. I think I said that already. Your business. If you don't have a other way to transfer your business, the will dictate what happens to your business as well. What happens to your pets? A will can dictate that. Who's the guardian of your minor children? If you have children under 18, the will is going to be the document that says who cares for them in the event that you and or the child's other parent can't do so. And it names a personal representative. Again, we're still talking about the will here. The will names a personal representative. You guys might be more familiar with the term executor. Florida doesn't use that term because we like to be different down here. We use the term personal representative. But when you hear executor or an executrix, it's the same thing as a personal representative. And I may use the terms interchangeably as well. Naming a personal representative is important, even if you're avoiding probate in other ways, because the personal representative is the person that if there are tax issues after your death, they can deal with the IRS. If there's Medicare issues, they can deal with that. If there's insurance issues, they can deal with that. If, let's say, you die because of someone's negligence, like in a car accident or a botched surgical procedure, your personal representative then is the person that can sue on behalf of your estate. So the will has a lot of things that it does. And if you remember what I said earlier, that even if you have a trust, you're going to have a will, is because it's the will that does some of these things that a trust doesn't do. So you would end up having both. The other thing about a will is that it is public record. So when a person dies, the statute in Florida says if someone has a will, you are to file that will within 10 days of their death. There's no criminal penalty if it doesn't happen. It doesn't happen in 10 days a lot. But that's the standard, is that it gets filed and then it's public record. Anyone can get on the clerk of court's website or go down to the public viewing computer at the clerk's office and view what the will says. And for a lot of people, that's problematic. They don't want everything that their wishes are to be out there and be public record. So that is what a will is. Now we're going to jump to what is a trust. Now, this is an important thing to remember. What I'm going to talk about today is a revocable living trust. There are dozens upon dozens upon dozens of types of trusts out there. Revocable trust, irrevocable trusts, special needs trusts. We're talking today for the estate planning process arena, the revocable living trust. And what the revocable living trust means is that it's changeable, it's amendable. That's what the revocable living, those terms mean. You can take things in and out of the trust. You can get rid of the trust. And that's the kind of trust I'm going to be talking about today. So for me, my analogy that works for me, and the one I use with my clients is, rather than, remember that kind of garbled definition I gave you of the trust at the beginning, that it is the legal entity that you let someone else take care of the assets on behalf of a beneficiary, blah, 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 blah. Just throw that out with the baby and the bathwater. What I want you to think of when you think of a trust is think of a bucket. So, for example, instead of Liz owning her condo, Liz owning her bank account, Liz owning her investment account, Liz owning her, vacation home in Colorado, Liz creates a bucket, and it's Liz's revocable living trust bucket. So now I'm going to retitle these assets that I just talked about, and I'm going to put them into the bucket. So the house in St. Pete, I'll put in the bucket. Sorry, someone popped up there. Get distracted sometimes. The Colorado condo, I'll retitle into the bucket. The bank accounts, I'll retitle into the bucket. The brokerage account, I'll retitle into the bucket. And what I mean by retitle, it means instead of Liz Moneymaker owning the condo, now it's Liz Moneymaker's trust. The bucket owns these assets. And the reason that is helpful in the estate planning arena is that when Liz kicks the bucket, that was intentional. When I kick the bucket, my bucket lives because it's a non-living entity. So it will continue on. Therefore, all of these assets I have in my bucket avoid probate because they don't belong to me. They belong to the bucket. And then my instructions, which is the trust language itself, dictate what happens to the stuff in the bucket. A trust takes effect immediately after you sign it. It does avoid probate if done correctly. And I want you to remember that if done correctly, because we're going to come back to that in a little bit. It can help you in the case of incapacity. So think about it this way. So let's go back to my bucket. I have everything in my bucket. And let's say that I get hit by the proverbial bus and I'm in a coma in the hospital. Well, now whoever I've named in my trust, my bucket, to be my backup person in charge of all my stuff can now handle my things while I'm incapacitated. Same thing if someone develops Alzheimer's or, is otherwise mentally incapacitated. If they use a trust-based plan, all someone has to do is pick that bucket up and they can take care of the assets for the person who created the bucket. So it is a great tool for incapacity planning, whereas the will is not, because remember, a will only takes effect after somebody dies. The other thing about trusts that are helpful is that you can, what I like to call, control from the grave. So this is happens. This kind of planning happens a lot when we're talking about children, and you have minor children, for example. Well, you don't want your 10-year-old and your 12-year-old to inherit $1 million, let's say, or more or less. So what the trust lets you do is control from the grave and say, okay, they can get a distribution when they're 25, they can get another one when they're 30, something like that. So you can space out the distributions. It can be based on ages. It can be based on milestones like graduating from college, getting a job, buying a house, those types of things. There's really no rules about what you can or can't control with. It's more of, as long as it doesn't violate public policy, you can make that a parameter of your trust. I always caution people, though, because you don't want to put your successor trustee, the person that's in charge of your bucket after you die, you don't want to give them too hard of a job to do. So we always talk through thoroughly about any strings that you put on distribution. But the other thing a trust can do is not just for minor children. Let's say that you have a beneficiary with alcohol or drug problem. There can be strings attached to distributions there. Or, and this is a lot of my clientele that I can help, is what if the client is special needs and they're on public benefits? How do we structure the beneficiary designations so that if they do inherit, we're not kicking them off those public benefits? So generally speaking, when I'm talking to clients about whether they want a will-based plan or a trust-based plan, when we're talking about trusts, two main factors will lead me to suggest that they go the trust-based route. One is, can we not avoid probate any other way? And number two, do they need to control from the grave or want to control from the grave? Either, again, because they have minor kids or they have other reasons that they want to put strings attached to distributions. And lastly, the difference between a trust over a will is that a trust is private. It doesn't get filed with the court like the will does. So those strings you've attached, for example, those do not become a part of public record. So that is, in a nutshell, what a trust is. Now, I want to circle back to something that I said a little bit ago, and that was, if you're relying on a will to transfer assets, you must go through probate. What I don't want you to write down and tell people after this is that Liz Moneymaker said, if I have a will, I have to go through probate. It's not what I said. What I said is, if you are relying on a will to transfer ownership of assets, you will have to go through probate. All right, so what am I talking about? What's the difference there? Quit talking like a lawyer, Liz, and just talk like a normal human being. So, okay, let's try to do that. Think about yourself. A lot of you out there, you have real estate, a house, a condo, something. You have a checking account. You have a savings account. You might have an investment account. You might have retirement accounts. So there are ways for all of those assets that we can have them avoid probate when you die. And I have the slide up there for some examples. One example of how to avoid probate is by having joint accounts. And this often happens with married couples who commingle their assets. So if only one of the married person dies and they have these joint assets, the joint banking account, checking account, savings account automatically passes to the survivor. So joint assets is a way to avoid probate. I have a cautionary flag up there because I don't want you to just go out and put just anybody on your account. Put your kid on your account, put your cousin on your account, your neighbor Bob on your account, because there's problems. Because once you put someone as a co-owner, they own the account, and if they drain it, there's really nothing that you can do legally about it. Additionally, if they get sued or they declare bankruptcy, that account then could be attached. So you want to be careful about who you name as a joint owner of a bank account. And even more so, don't go and just putting someone on your deed, because that could really impact taxes and the ability to inherit the house via the homestead process. So anytime you think you want to do a joint ownership, definitely talk to someone that knows what they're doing when it comes to cautioning you about the risks associated with that. Other ways to avoid probate, even if you have a will-based plan, is for your checking, savings, money markets, you can go to the bank and you can put a pay on death designation on those accounts so that when you die, those accounts will be paid to that beneficiary that you've listed on that pay on death designation. Same thing with your investment accounts, your brokerage accounts. I'm not talking about retirement yet, but your investment brokerage accounts that are taxable accounts, you can put transfer on death, what they call TOD designations on those. So again, when you die, that asset will pass directly to the beneficiary that you put on that transfer on death form. For retirement accounts, life insurance, and annuities, all of those have the ability to have beneficiaries on them. So when you list the beneficiaries, that is who those assets are going to go to, and it's going to pass outside of the probate process. When I'm counseling people about their estate planning, we go to what is the simplest way we can accomplish your goals. And for a lot of people, it is with a will-based plan that we then attach these other planning tools to the beneficiaries, the transfer on death, the pay on death. And then lastly, in Florida, if you're joining us outside of Florida, this doesn't apply to you, but for us Floridians, we have something called a ladybird deed. It's also called an enhanced life estate deed. I won't bore you with the details of the ladybird deed, but just suffice it to say that you can put a beneficiary on a deed so that, for example, let's go back to my condo. Let's say I want my condo to go to Vicky when I die. Well, I would do a ladybird deed that said, Liz owns this condo. Liz has it for the rest of her life. She can sell it. She can refinance it. She can do whatever she wants to with it. But if she owns it at her death, it automatically then passes to Vicky and avoids probate. So these are some ways you can avoid probate, but still have a will-based plan. So remember, if you're relying on a will to avoid probate, you will, if you're relying on a will to transfer your assets, you can't avoid probate. But if you use a will as a simple estate planning tool and you add these other tools to it, you can avoid probate. All right, one more slide and then we'll get into your questions. At least I thought I did. Maybe I didn't. All right. I guess I didn't have one more slide, but I did have one more point I wanted to make. Remember when I was talking about trusts and I did the analogy of the bucket. And I said a properly funded trust, so a properly filled bucket avoids probate. This is what kicks people in the pants more than anything about a trust. Because maybe they go online and they print one off. I've had clients come into me that did that. Or maybe they went to a lawyer that wasn't thorough with them. And anyway, what they ended up with is 50 pages of paper that said what they wanted. So what they went home with then is an empty bucket. So unless you are taking that additional step and making sure your assets are retitled into the bucket, you have a very expensive, useless, empty bucket. you've actually now doubled the work for your heirs because not only is the bucket empty, but they're going to have to go through probate, fill the bucket, and then empty the bucket through the trust administration process. Would have been better off not to have a bucket at all. So if you're going to go the trust route, you need to make sure that you just don't go home with your pretty binder, your pretty pieces of paper. You ensure that it gets properly funded. You can do that yourself. You can have your attorney help you. The most important thing is that you don't put it on the shelf and forget about it after you, especially if you've spent the money on a trust, because it won't do you the good that you think that it did. All right, so I'm going to jump on the chat because I know we have some questions there. Okay. So is the will filed by the lawyer? So Debbie, I think you're going back to what I said about the Florida statute says you have 10 days to file it. Typically, it's filed by the lawyer. If I'm doing the probate, I definitely want to be the one that files it. But I've had clients that have filed it themselves. But either way, it's really just taking it to the clerk, and the clerk puts the original will on file. Next question. Can a married couple with real estate assets in respective names put the real estate assets in a shared trust? Sally, you can. There could be some issues with that. I would just talk to you about, are they homestead, are they investment properties, that type of thing. But yes, that can happen. It may not be the wisest move depending on what your strategy is, but it certainly can happen. Richard, are there any advantages at all to probate? Well, if you ask lawyers, yes, there's an advantage to probate because we get paid for it. So that's really not the advantage you want. But there are advantages in that. Let's say that you have beneficiaries, let's use kids, for example, that don't get along. So the probate process is overseen by a judge. So you can ensure that everything has to be clearly accounted for and distributed. So in that's an example where a probate might be advantageous. But generally speaking, we don't find a lot of advantages to the probate process. It just slows things down. Next question. Non-Florida resident owns property in Florida. Can a ladybird deed be used for Florida property? Absolutely. As long as the property is in Florida, a non-Floridian can use a ladybird deed for the Florida property, for sure. And we wish that there were other states, and there are a few others that do something like a ladybird deed. But generally speaking, if I have clients that own property here in Florida and they own, a North Carolina vacation home, for example, we're going to be stuck doing a trust plan if they're wanting to avoid probate. Because what happens is for people that own property, like real estate out of Florida, if you don't have another mechanism to transfer that asset upon your death, then your beneficiaries have to open up a probate in that state as well. So I've had some cases where we've had as many as 5 different states we've had to open probates in because the person who died had stuff everywhere. Don't do that to your heirs, for sure. There are ways that we can help you keep that from happening. Oh, and Richard answered you, Sally. So I didn't even need to answer that. So thank you, Richard. You can come to lunch with Liz anytime. Debbie, regarding funding a trust, does this mean financial accounts need to be renamed RE ownership? Yes. So your Debbie brokerage account is now Debbie Trust brokerage account. Caveat to that, though, because I'm a lawyer and everything depends, right? Sometimes financial institutions won't close a checking or savings account and rename it into the trust account unless you completely close and reopen a brand new one with a new account number. And some of my clients don't want to do that. They have direct deposits, they have auto pays, and the thought of having to do that makes their head explode. So the workaround to that is, remember I was talking about the pay on death designations? Well, we can make the trust the pay on death designee of those accounts, or you can use those accounts pay on death to one of your primary beneficiaries, for example. So there are different ways that you can work around that one. Okay, can properties owned abroad outside of the US be put into the trust here in Florida? Great question, but the answer is no. Um, our Floridian trusts or US trusts can only hold US property. Out assets out of the country are dealt with by that country's laws. So, for example, I have clients with houses in Portugal and France. Well, they had to go to the legal representative in those countries to coordinate those assets. Because think about it, all those countries have different rules about, who inherits, how they inherit, whether you own for life or whether you have a lease, that kind of stuff. So, Richard, doesn't probate limit the claims period? Um, yes, probate does limit the claims period. There's a 90-day limit in a will-based probate. There's a 2-year limit in if it's a trust probate. So I think, Richard, you're being the A+ student and saying, is there a benefit to probate? Yeah, if you're concerned about creditors, there could be a reason to do probate to cut off the creditor period. We find that when we're dealing with businesses, sometimes that is your better course of action. But generally speaking, cutting off that claim period isn't sufficient to warrant the probate. It certainly could be, and certainly that's something you take into consideration with every scenario. Okay, Robin, if one has business accounts, is it advisable to put in a trust if we don't want to put spouse on business account as co-owner? That's a lot, and I don't think I can answer that fully for you in this particular venue. It's going to depend on how your business is owned. It's going to depend on what your operating agreement or your shareholder agreement says. So that would be something I would need to talk to you about on a case by case basis about what's the best thing to do for the business, for sure. Generally speaking, it's hard to avoid probate with a business unless you have a trust. It can be done, but generally speaking, that's the general rule of thumb. Next question. I have a scenario that I prefer to. Okay. So I do not take calls just after lunch with Liz, but if you want to book a consultation, then Vicky will put our information in the chat where we can do that for sure. Thierry, can you update the living trust bucket list as needed, or do you have to restart the process? You can update it as needed. So that's the great thing about a trust, a revocable living trust, is that you can make changes. So for example, let's say the person you put in charge after you, so we call that your successor trustee, let's say they pass away or become incapacitated. Well, a good lawyer would make sure you already had a backup in the document. But let's say that you didn't. Well, you can amend it to add someone else. Or let's say you had a falling out with that person. We can amend it to add someone else. Let's say that initially you wanted everything to go to your sister, but then your sister ticked you off. So we can change it so now it goes to charity, for example. So we can do what's called an amendment to the trust, where we just change a little bit. But if it's a significant change, we do what's called a restatement, where we just restate the whole thing. But generally speaking, all your hard work and expense is at the beginning when you're creating the trust. See. Please touch on how to avoid abuse by the beneficiary in cases of incapacitation. Well, first of all, your beneficiary in in most cases, we don't want the beneficiary to be your trustee. So let's say you're incapacitated, that and in your bucket is eventually going to go to your children, let's just say. Well, let's not put the children in charge of the bucket then. Your successor trustee, the person in charge of your stuff, is your sister or a professional fiduciary. There are professional fiduciaries out there that's their job. They help run people's buckets and oversee people's buckets. So that's the easiest way, Lynn, is just to, keep the fox out of the hen house, so to speak. Otherwise, the only other safeguard really is the other beneficiaries yelling. And if you just have one beneficiary, let's say you have one child and you've named that child the beneficiary and the trustee, if you're incapacitated, who's going to be the one double checking that? There's not the trust police out there to be double checking that. So that's certainly something most attorneys are going to talk to their clients about, is like what makes sense to protect you and protect your assets in the event that you can't do it yourself. Okay. How are liabilities handled for beneficiary? Co-sign on a mortgage, vehicle loan. So I'm going to assume you mean in a trust, and let's say that I've named my son as beneficiary, and I'm alive, and it's still my bucket and my money. Nothing that he does with his loans or his debts will impact anything having to do with my bucket. But let's say I've kicked the bucket and now he's getting payouts. Well, my trust that I draft will have language in there that will prevent any creditor from being able to lay a claim to what was left of the bucket. Now, once he gets paid, let's say he gets $25,000 a year. Once that $25,000 is in his pocket, there's nothing I can do. I can't control that far, but I can keep the stuff that's in the bucket safe from any potential creditors. So if you were retained to do a trust, if something happens to you, who takes over for you? Do you mean me personally? Like if I draft the trust? Yeah, I mean, I probably won't live forever, nor will I practice law forever. So generally speaking, you can go to any other lawyer to update or to do a new trust or to administer your trust. And by administer your trust, I mean, ensure that the laws are followed about distributions from it. I will give you a caveat there, though, that a lot of attorneys, myself included, I don't amend trusts that someone else did, and with very few exceptions. So if someone's coming to me with a trust that they got done, by a Tampa lawyer, for example, then and you want to make changes, then we're going to do what I had mentioned to Terry when I answered his question, is we're going to restate it. Because I can't vouch for everything that attorney did. I want to be able to vouch for everything to you and to your heirs. So if, if I mess up, then we want to make sure that your heirs have someone to come to, and it would be me in my malpractice insurance. And I hope that answers your question. If it didn't, circle back with me. Next question. If my government pension gets direct deposited into the checking account with my name on it, but then I change the name on the account to the name of the trust, could I have a problem getting my pension to send my benefits to the trust's name? Potentially, that's something to talk to the custodian of your pension about. But again, there's a workaround for that. You just keep your account in your name and you put a pay on death designation on that account, either making the trust the beneficiary or one of your other, primary beneficiaries, the beneficiary of that account. It's usually not a deal breaker to get that workaround and still avoid the probate process. There are a lot of professional fiduciaries, and what I mean by professional fiduciaries, there's people out there that are trained to run trusts themselves for other people. They prefer to have an account outside of the trust for different reasons. So it's not the end of the world. It probably happens more often that way than it does by having everything in the trust. Oh, thank you, Debbie. All right, I'm in Florida. If my home is homesteaded and my accounts all have named beneficiaries, do I still need a trust to avoid probate? Well, Susan, I'm going to give you first of all, it depends because I haven't sat down with you and I haven't done a holistic interview with you to know exactly what you have. But generally speaking, if all of your accounts have beneficiaries and you have homestead, there will be a short probate process called a determination of homestead status. If you are leaving, I should have caveated this. If you are leaving your homestead to your natural heirs, so children, for example, then you'll have that abbreviated probate process called determination of homestead status. So it doesn't avoid probate per se because there still will have to be a court process. The only way to completely avoid that is by using that Ladybird deed tool that I talked to you about a little bit earlier, where you put a beneficiary on the deed. One thing I wanted to say about that too is, let's say that you have a will, and in the will you leave your homestead property to your best friend or your significant other who is not you're not married to. Well, if you do that and it's your homestead, they don't inherit it as homestead. So it is subject to creditor claims if you do it that way. Homestead is only exempt from creditor claims if you're leaving it to heirs who would inherit otherwise. So again, this is what I mean about needing to, have this conversation with you so we understand exactly what you're trying to do. I've had several cases where someone has left a homestead to a non-relative, to a best friend, for example. And in one case that I have right now, there's about $100,000 Medicaid lien that if the homestead property had gone to an heir, then it would have been exempt from that lien. But in this case, we had to sell the property to pay the lien. What if my heirs are not blood relations and they all live out of state? Can I still do a trust? Also needs someone who's a Florida resident. Okay, so you can still do a trust. Your trustee does not have to be related to you or a Florida resident. I'm not sure I understand that question, Debbie. So if you want to ask me or come off mute, whatever you want to do, if you want to rephrase it. You can do a trust. I've been told that I need a Florida resident as part of a trust. No, I think what that confusion is, for a will to be an executor, to be a personal representative in Florida, the person either has to live in Florida or they have to be related to you, one or the two. It can be your cousin from Oklahoma because they're related to you, or it can be your best friend from Seminole because they live in Florida, one or the other. That's the executor of the will. To be trustee of a trust, so the person that's going to be the backup to your bucket head, that can be a person from any state, doesn't matter if they're related to you or not. So oftentimes what we end up having, if let's say you want your best friend from Indiana to be your trustee and be in charge of your bucket if you become incapacitated or die. So we can do that. But remember when I said if you have a trust-based plan, you're also going to have a will because a will needs to name the executor. That best friend from Indiana can't serve as executor. So we have to figure out something else for that. But if we do our jobs right, that executor is probably not going to have anything to do. We hope, unless you died because of a car accident or something like that. But that's a discussion I would have with a client about, what makes the most sense. Sometimes there's just nobody in Florida that you trust or that you can put in these positions. So we have to figure out other things. One way is a professional fiduciary, um, especially if there's nobody in Florida that can act as executor.
Okay, I took off. I think you can hear me.
Yeah, I can hear you.
Great. Okay, good. So if I have a trusted Florida friend that is willing to do the executor of the will role, so to speak, and their entire role in this thing is to just hand it off to my best friend of 50 plus years who does not live in Florida, then that would be okay.
Correct.
Very good. Thank you.
Correct. Yeah. All right. And I've come to the end of the chat questions, but if you have another one, throw it in there. But if there's anyone that wants to jump off mute and get a clarification, I don't want you leaving today with, not sure that you understand the difference, or, if you want to run a scenario by me, um, we can do it that way. Um, the bottom line is, can you avoid probate with a will-based plan? You can, depending on what your assets. And that's certainly one of the first things I look at. My objective typically is, what's the simplest way to accomplish your goal? You know what simple usually means? Least expensive. So that usually is the way my clients will want to go. But sometimes there's just no way to accomplish your goals without doing a more complex plan. And more complex does mean a more expensive plan. But what I've found throughout probably too many years of doing this now is that the more complex we get people, the more difficult it is for them to sustain that and keep it going. And then when they do pass away, the neat little box that was done 20 years ago is now all over the place. Whereas if we had kept it a little simpler, then, it would have been easier for the client to maintain. Not at all saying that this group here wouldn't be perfectly capable of maintaining a more complex plan. We just walk through both when we're doing a consultation, and the client decides what they want to do. I don't have a dog in that fight other than to lay everything out, and see what works best for you. I think there might be another question. No, no other questions. I'm going to hang out. If you are done and you want to take off, please feel free. But if you have other questions that you're just too shy to ask in front of everyone, I'm going to hang out here for a little bit. It was great to see your faces, see a couple of familiar ones. One I haven't seen in a very long time. Terry, good to see you. Um, all right. Thanks, everybody. If you love Lunch with Liz, next month we are going to talk about estate planning for single people and unmarried couples. And then in November, we're going to have a special guest, and we're going to talk about executors and trustees. So, two perspectives on that. One, if you've been named in that role, like, what the heck are you supposed to do? And then number two is, what are they supposed to do, so that I know, does my best friend of 51 years, is that a role she actually should do or can do? So that's November. So hopefully we'll see you back. If you would like to speak to me at a complimentary consultation, you can give Vicki a call or shoot her an email, and she'd be happy to set that up. So thanks for being here.
Hey, Liz.
Hey,
I had a quick question, and I'm sorry if I missed it because we were chatting on something, but I was the one that was asking the quick question about the power of attorney and health
did
director.
I miss that? I'm sorry.
Oh, okay. So the question I had in here is, do trusts include the power of attorney and health directives while still living and, in our case, unmarried? So would that
So
be the kind of the entity we would go through to make sure that we had directives over each other?
So any plan that I do, whether it's a will-based plan or a trust-based plan, is going to include your powers of attorney for finances and all your medical directives. So your living will and your
Oh,
designation of healthcare surrogate. To me, honestly, those are the most important documents, especially
yeah.
as an unmarried couple. Um,
Yeah.
yeah.
living in Florida.
Yes. Yeah.
Okay, cool. That's awesome. Thank you. Appreciate
Yeah,
it.
you bet. Sorry, I missed that one.
The best way to follow up then is just through Vicky to set up the consultation and then go from there.
Correct.
Okay, and then we're planning on October as well because that sounds like it's right up our alley.
Perfect.
Well,
Yeah,
since we're not
absolutely.
very a couple,
Yeah.
but
Yeah.
okay,
Perfect.
sounds
I'll
good.
use you as my example throughout the whole entire
Oh,
presentation.
perfect.
Hello.
Um,
All right. Well, thank you so much
Yeah,
for
thanks,
offering
Liz.
this.
You
and
bet. You bet,
look
guys.
forward
Good to see you.
setting up a consultation, meeting you in person, and then, like I said, we'll be on in October.
Perfect. Anybody else before we need to close out? All right. Well, I thank you
Liz,
all
I
for
just wanted to say hi. It's so good to see you. And I'm going to call Vicky and set an appointment up, and we'll catch up there too.
Perfect. Perfect. Just so you know, I know you're in Sarasota, so we do offer Zoom if you don't want to make the drive to St. Pete. So I
Okay.
actually do estate planning all over Florida and probate all over Florida because modern technology is an amazing thing.
If we can do it that whichever way we could do it is great. But
All right.
I love you and I trust you, so thank you.
All right,
It's good
Terry.
to
Good to
see
see
you.
you.
Thanks for doing this too.
You bet. Good to see you.
Bye bye.
All right, I'm going to sign out now. If you would like to reach us, Vicky put her info in the chat and have a great month.